right, we have everybody back. Okay, we're about to bring the jury in. When the jury comes, please all stand. That's standard court protocol, and that's a sign of respect for people that are doing their civic duty. So when we get everybody back in, I'm going to ask the bailiff to bring in our jury. So everybody, please go ahead and stand at this time. Where'd our bailiff go?
He's getting to it, Joe. He just heard you.
Okay, be seated, please. All right, Mr. White.
Thank you, Your Honor. May it
Prepared
please
to
the court.
cross-examine?
Sorry.
Prepared to cross-examine?
Yes, sir, Judge. May it
All right.
please the court. I apologize for stepping on your toes there. Officer Elam, may I call you officer or should I call you trooper? I'm not sure which one's, is it, you're a trooper, I know, but you're officer, so.
Whatever
Matter
you
to you?
decide. No, sir.
Okay, I may call you both, okay? So let's go back to this, the time of the stop that you described for us. You described that you went up to the truck and it was, of course, at a safety checkpoint, and he stopped in front of you and Officer Richburg.
Yes, sir.
Is that right?
Yes, sir.
And so you were how far from the truck?
I would say distance is hard to describe right now, probably from me to you.
Okay, so you weren't at the door of the truck, like in his window, as we would think, like standing right beside the truck.
Oh, no, when I made my initial approach before he arrived. I
Okay,
was,
so then you did walk to the truck?
yes, sir.
And are you the one that got him out of the truck?
Me?
Did you testify you got him out of the truck?
Yes, sir.
You sure it wasn't Officer Richburg or another officer?
Not that I recall.
Are you sure that they're not the ones that talked to him first, and that's why it's not on your body cam?
Not that I know
You specific, I'm asking you, I'm not trying to put words in your mouth, but do you specifically remember that it was you that approached his truck when he first pulled up to the checkpoint?
of. It was me and Corporal Richburg.
You and Corporal Richburg, okay. So when did you, where were you and how close were you when you smelled the odor of marijuana and alcohol?
At his door.
Standing just right next to it by that time?
Yes, sir.
Okay. Upon seeing the open container and smelling what you smelled, did you get him out immediately? Did you talk to him? Did you ask him for his license and registration?
Asked him for his license registration.
All right, he produced that?
Yes, sir.
Was he able to find that in his truck?
He was able to provide his driver's license. When he provided his driver's license, I asked him to step out.
Okay, all right, so he was able to do that. I mean, functionally, he was able to do that. He didn't blunder trying to get his license out?
No, sir.
Okay. You patted him down outside the vehicle, you said. Did you find anything on his person?
No,
This is
sir.
illegal?
No, sir.
You testified that his eyes were bloodshot, he had smell of alcohol or odor of alcohol on his person.
Yes,
Did
sir.
you smell that come from his person or from his breath?
From the vehicle and on him, and his breath.
So all three?
Yes, sir.
Okay. And you testified he was unsteady on his feet or unsteady balance. I wrote unsteady balance. I don't remember exactly how you said it. Is that correct?
Yes, sir.
And unable to follow instructions. Is
Yes,
that
sir.
right? All right. You also said that his speech was very slurred. You used the word very, didn't you?
Yes, sir.
Okay. You testified that he had a hard time walking.
Yes, sir.
Was that your words?
Yes, sir.
Okay. And I guess that would be relative to his unsteady balance, correct?
Yes, sir.
Did he ever fall down? Did he ever stumble?
He stumbled several.
Okay. Did he do that after the video started or before the video started?
Before the video.
So we'll strike that. So when this video starts, we see him walking from another squad car, another unit of yours, right? Across the intersection.
Yes,
Do you
sir.
remember that?
Yes, sir.
And what I saw was, and I'm asking you if that's what you saw, is that Mr. Carnley was walking from another squad vehicle, another trooper vehicle, all the way across the intersection to where you were.
Yes, sir.
Is that what you saw?
Yes, sir.
Did you see him stumble on that video?
The initial, no, sir.
Okay, so he walked all the way across there and did not stumble.
No, sir.
He walked to your car, is that correct?
Yes, sir.
At that point, you put him in the squad car.
Yes, sir.
When the heck did he stumble?
Prior to the video.
Prior to the video, he stumbled, but clearly he could walk. He walked straight from that unit back to you. Is that right?
Judge, I'm gonna object.
Unescorted.
Asked and answered.
Okay. Ask another question, Mr. White.
Yes, Judge. I'll move on. Judge, may we play that video and watch that portion of it? I'll have to ask Mr. Witt to help me with the computer since he's got the computer,
You may.
the tech savviness that I don't have.
Get one or two more, Jack.
Officer, I'll ask you to watch when it does start, so you'll see what I see, okay?
Yes, sir.
So I can ask you questions about it. Well, not right when it starts, because we have this preliminary.
Got that there? Yeah. Okay. Come on over here for a minute. Okay. I mean, when was the last time you had a little bit of alcohol?
It's been a little while to get.
All right, sit up in here.
Stop it. Thank you, Judge. Officer, you watched that video clip just then?
Yes, sir.
Did you see him stumble at any time through that walk?
Yes, sir. Prior to that, right there.
Prior to what?
To that, like 2 seconds prior.
He stumbled?
Yes, sir.
Can you back that up, Mr. Witt?
Alcohol.
It's been a little while to get.
All right, sit up in here for a minute. Okay.
Stop it. Was it in that clip?
Yes, sir.
You saw a stumble?
Yes, sir. It might have been the angle.
Okay, all right. The video is what it is. So you saw a stumble, but the video is evidence. That's good. Thank you. You testified again that his speech was slurred, and we're gonna get right back to it. That his speech was slurred, and the video, you claim that is slurred speech that you heard in that video?
Yes, sir.
Okay. All right, you can play it.
It's right there.
I'd rather not, but
Yeah, go right here. Okay. Got anything in your pockets, buddy?
money,
All right, go ahead and let's double check, all right? Pull everything out of your pocket. Ain't got no Derringer or nothing in there, do you? I got you. Let me see you back. No, keep your foot in there. Keep that right foot in there for me, okay? All right, then pull your ball.
Got some screws and nails in the back pocket.
All right, let's get those out.
Actually, it's their key. That car right there is the key to their house, so I gotta have that.
Hey, sir. Rick. Hey, man, hold up a second. All right, go ahead. Let me see that foot. See you been drinking too?
No.
Oh, keep your foot in there, buddy. I told you to keep your right foot in there.
I was trying to reach in my pocket.
Okay. Well, you can do that from where you at.
A little bit harder, but it's just changed, man.
All right, well, keep that in your pocket, all right? Double check your pockets. All right, lean over to your right. All right. Now let me check your back. All right, money. All right, you do? All right, I got you. What do you think it is? Yeah, you gonna go to jail tonight, all right? Well,
Stop for it.
all right, DUI.
You up?
Jake, you turn the lights back on, thank you. So, what was it about when he got in the car that made you just tell him he's under arrest? I'm not sorry, you didn't ever tell him he was under arrest. You said he's going to jail. What was it that led to that moment?
The evidence prior to the encounter with dealing with him and when dealing with him being uncooperative.
All right, so it's your testimony that what you saw in that video was, or heard, was slurred speech,
Yes, sir.
and he didn't follow instructions. Let's talk about that for a second. If not following instructions, was he put his foot outside the car, is that right?
Yes, sir.
Did you ever tell him not to put his foot outside the car?
Yes, several times.
When did you tell him that, officer, on that video?
When I told him to put his foot back in, and then he kept moving out, I told him twice, keep your foot in there.
Okay, but you didn't tell him when you set him in the car, sir, keep your feet in the car. You just said, sit in the car, didn't you?
Yes, sir.
You didn't tell him anything about his feet, and obviously he's trying to dig in his pockets and get what he can get out that you've asked him for, and for him to do that, putting his foot outside would be a lot easier. Do you understand that?
I can see.
I'm sorry?
Yes, sir.
So you agree that that's a reason to put your foot outside to try to get the money that you were asking for out of his pocket and the screws out of his back pocket?
No.
Did you ever ask him if he had dentures?
No, sir.
Objection relevant.
To slurred speech. Relevant.
Overruled.
Did you ask him, I misunderstood or maybe I misheard your testimony about field sobriety test. Did you give him field sobriety test?
No, sir.
None?
No.
Why not?
Due to him being him uncooperative prior to the video.
Based on the, prior to the video that we can't see,
Yes, sir.
is what you deemed him to be uncooperative for.
Yes, sir.
Yet, in that video, he's standing across the intersection at another vehicle by himself, is he not?
Yes, sir.
If he was uncooperative, why would you allow him to stand by himself across the intersection, officer?
Due to the traffic. It was a safe location from where we were.
Did you see any cars going by there? There was only one car that passed, wasn't it? Do you remember that?
Yes, sir, but there were several vehicles there also.
Okay, so, all right, we'll let the video be its own evidence as it would be, the best evidence. So when you got the items out of his pocket, you then told him he's under arrest, and that was just based on the totality, right?
Yes, sir.
So, you're probably, well, strike that. All right, let's talk about after you placed him under arrest. The video shows, and I don't think we need to replay it. You got him out of the front seat, stood him up, did a pat down again, as you testified to, and you placed him in handcuffs behind his back. Is that correct?
Yes, sir.
At what point of that was he uncooperative?
Whenever I told him to spread his legs, he kept not wanting to spread his legs. He kept his base straight.
So just kept his legs completely straight, or did he sort of do it?
No, sir, he wasn't. He was trying to put him back where he could stand straight up.
So to your satisfaction, he didn't perform?
Yes, sir.
Just to your satisfaction?
No, sir, to officer safety.
Well, you're the judge of that, are you not?
Yes, sir.
Okay. Was he stumbling when he did that?
He was having a hard time standing up.
Is that what the video showed? Did you see that on the video?
As far as,
Stumbling, when you had him outside the car?
no,
Okay. Did you hear his speech on there? And I may have asked this, I'm sorry if I did. When he hollered at the other folks, was his speech slurred?
yes, sir.
In your opinion, it was?
Yes, sir.
All right. You completed the UTC complaint form, is that right?
Yes, sir.
And that is a document that you signed and it's under oath, is that correct?
Yes, sir.
All right. And it says, and you've seen it, I think it's in evidence, this occurred March 11th, 2023 at 3:45 p.m., is that right?
Yes, sir.
And you gave him the test at 16:28, so let's clarify that in case the jury doesn't follow that. I think they probably would, but 3:45 is regular time, is that right?
Yes, sir.
3:45 p.m.,
Yes, sir.
which would also be 15:45, am I right?
Yes, sir.
In military time.
Yes, sir.
And the test results have military time, is that correct?
Yes, sir.
All right. Where did you observe him for 20 minutes prior to the test that occurred at 16:28 or 4:28?
In between the trip to the jail, at the jail, while the Drager is preparing his self-test.
How long did it take you to get him into the jail?
I do not recall.
How long does it take the Drager to warm up and do the self-test?
I do not recall.
Do you have him in your sight the whole time from the scene to the sheriff's department?
Yes, sir.
In your rearview mirror?
Yes, sir.
Was he handcuffed in your back seat?
Yes, sir.
Do you know how long you spent on the scene after you arrested him?
I do not recall.
That's not on video, is it?
No, sir.
Just like the first part's not on video, that part's not on video. So, how far is it from out there County Road 10 and 45 to the county jail?
Around 30 minutes.
So it took you 30 minutes to drive it?
Yes, sir.
Okay. So if it happened at 3:45, you know how long it took you on scene to do all these, all of what you did and to do what happened on the video?
No, sir, I don't recall.
You don't have any idea?
No, sir.
Okay. When you input information in, we'll strike that. The Drager is only as good as the information input into it by you, is that correct?
No.
If you input incorrect information, will it kick it back to you?
No, sir.
Okay, so it's gonna run the test either way?
Yes, sir.
All right. Would you say that the report that it generates is truthful?
Yes, sir.
And could it contain any mistakes?
Yes, sir.
All right, how does that happen?
By human error.
Okay, so if I show you, or you can see the exhibit, the state's exhibit number 1. Can you look at the time of the offense?
Yes, sir.
And what is that time of offense?
13:45.
So that's a mistake, is it not?
Yes, sir.
Because we clearly just said it was 3:45, is that right?
Yes, sir.
13:45 would be 1:45, right?
Correct.
So which one is truthful? Which document? You signed, that's under oath, is it not?
Yes, sir.
So which document is the correct document, or let me ask it a different way. Which document is correct? Was it-
Objection, he's got two documents there, they're both the same.
I'm sorry, I'm holding the wrong one, but out of the ticket, I understand, thank you, Mr. Witt. Between the ticket, the UTTC form, and the Drager results, which one is correct?
Both.
this one's got an error in it, does it not? The exhibit number 1?
Yes, sir.
Okay. You made a mistake?
Yes, sir.
Okay. Do you make mistakes?
Yes, sir.
Does the Drager ever make mistakes?
No, sir.
Does it kick back tests sometimes?
No, sir.
It never does?
Not that I recall.
Is there, is it a machine?
Yes, sir.
So machines make mistakes, don't they?
Yes, sir.
Would you agree that the Drager's not perfect?
Yes, sir.
Much like, for instance, I mean, railroad crossing arms, for instance, are a machine, is that right?
Yes, sir.
Have you seen them malfunction?
Yes, sir.
And so if they can do that, and that's a very serious thing.
I object.
Can
This is
you-
a hypothetical, not related. I mean, there's a speculation on comparing railroad arms to a Drager machine. Let's move along, Mr. White.
Yes, Judge. So this Drager is also a machine and it could malfunction as well, is that right?
Yes, sir.
Okay. You said yes, sir?
Yes, sir.
Okay. When did you testify that you never read him as Miranda rights?
Yes, sir.
Why did you not read him as Miranda rights?
You don't need to, when asking about a deal, you don't need Miranda rights unless you're in custody and you're being questioned.
Okay, but well, let's talk about that. When did you actually consider him to be under arrest?
When I told him he was under arrest.
In the car? I mean, after you had already got his stuff out of his pockets at that point?
Yes, sir.
So what about that time that he was in the car prior to that? Was he free to leave?
No, sir.
So wouldn't you consider that to be detained, under arrest?
No, detained and under arrest, two different.
Was he, he wasn't free to leave though?
No, sir.
So you were detaining him for the purpose of a DUI?
For the purpose of investigation.
Well, by your testimony, you'd already seen the stumbling and or the unsteady balance, the slurred speech, the smell, the odor of alcohol. Had you not made your mind up at that point?
At the, what do you mean?
When he was in the car, before you got there, you had already heard all of that. So why did you then tell him he was under arrest and then not read him his Miranda rights?
Because I wasn't questioning about anything else.
But if he had said on the way to the department, strike that. If he had said on the way to the department, I drank a case of beer this morning, you would have used that against him, wouldn't you?
I didn't.
So shouldn't you have read him his Miranda rights to protect him?
No, when you're being questioned about.
Were you saying something? I'm sorry.
No, sir, I just said
Okay.
that.
All right. Just one second. What other mistakes did you make in the making of this case, officer, besides the one on the state's exhibit number 1?
Objection, argumentative.
Just ask the question, Your Honor.
Overruled.
You can answer. What other mistakes did you make in the making of this case?
None.
None? Okay. But all of what you've testified about is your subjective opinion of those things. Is that correct, as far as the speech and the walking and all of that?
Yes, sir.
Would you agree that the video is the best evidence?
No, sir.
Looking at that video is not better than your testimony?
Hindsight's 20/20.
Well, officer, don't you agree that being able to watch what actually happened is better and more truthful or less biased than your testimony? Would you agree with that?
No.
Okay. You worked 4.5 years for the state of Alabama, is that correct?
Yes, sir.
How many DUIs have you made in that 4.5 years?
Over 100.
I'm sorry.
Over 100.
Do you know what the outcome of those DUIs were?
No, sir.
You don't keep up with how many plead guilty, or how many are tried and found guilty?
Object.
Or how
to the
many were
relevance. We're
acquitted?
not- Object to the relevance of this line of questioning. We're not here for all the other DUIs he was on. We're here for this one.
Judge, it goes to credibility.
Sustain the objection.
No further questions.
You ready?
Just a couple, Your Honor. Trooper, when, Mr. Carnley, when you had him propped up against the vehicle,
Object, Your Honor, there's no testimony that was propped up against the vehicle.
Your Honor, he
That
was,
assumes
Your Honor,
that's
he
not
was,
in evidence.
Your Honor, he was, when he,
And
it
it's
was
highly
on the
pre-
video.
it's highly
It was on the
prejudicial.
video when he was
Okay,
there.
okay. One at a time. Let Mr. White finish his objection.
Judge, we object because that assumes facts not in evidence. He was not propped up. Nobody has said he was propped up upon the vehicle.
Response.
Your Honor, there was testimony, there was video, he had to place his hands on the vehicle, he was trying to get him to spread his legs. I'm sorry the word.
Rephrase your question, Mr. Witt.
Did you have him place his hands on the vehicle?
Yes, sir.
When you had him place his hands on the vehicle, did you ask him to spread his legs?
Yes, sir.
Okay. When you asked him that, was he having trouble keeping his balance?
Yes, sir.
Let's go to the Drake machine. I believe you already testified. Was it, did you test it or is it a self-test?
It's a self-test.
Okay, did it test before he blew into the machine?
It's self-test before, in between both breaths, and after.
Okay. And the self-test, did it come back that the machine was working properly?
Yes, sir.
No further questions, Your Honor.
Officer, just a question or two. You told him, when you put him in the car, you didn't say keep both feet inside, right?
Yes, sir.
When you got him out of the car and you told him to spread his feet, did you tell him how far?
No, sir.
You didn't tell him how far. So how was he supposed to know how far? Did you want his feet a foot apart? Did you want them 3 feet apart? You didn't tell him that, did you?
No, sir.
Okay. Just in your opinion, he didn't do what you thought he should have done.
Correct.
Okay, no further questions.
Just one, Your Honor.
Okay.
When you asked him to spread his legs, did he put his legs back together?
Yes, sir.
No further questions.
No further questions.
All right. Trooper Elam, you may step down. Next witness, state.
State rest, Your Honor.
All right.
May we approach?
You may. All right, Mr. White.
Mr. Judge, the defense would move for a judgment of acquittal at the close of the state's evidence, and that we believe that they failed to prove a prima facie case of driving under the influence of alcohol as charged in the uniform traffic citation.
State.
Your Honor, we believe that we have proved beyond a reasonable doubt that the defendant is guilty of driving under the influence based on the actions of the defendant, the speech of the defendant, and the what's been entered in evidence of the Draeger of having a .09 blood alcohol content. We ask that the motion for judgment of acquittal be denied.
Okay. All right, based upon the charge under that specific subsection, find that the state has presented sufficient evidence for the case to continue for the jury. So, Mr. White, I'm going to deny your motion at this time. Now, ladies and gentlemen of the jury, this is normally a portion that the jury is excused for. So, this is a legal motion that is routinely made, and I have to rule on it based upon what I see the facts and the law are. So you are not to draw any conclusions as to my ruling on any motions or objections as I previously instructed you, okay? All right, Mr. White, the state has rested.
Yes, Judge. Judge, the defense would rest, and we would ask the court to instruct the jury on my client's right under the Constitution not to testify, if the court would so do that.
I will do so. Okay. Ladies and gentlemen of the jury, both sides have rested. That means they have concluded their cases. At this time, they will come to you with closing arguments. So the state will be able to go first. State ready?
Yes, Your Honor.
Okay, you may proceed to closing.
Yes, Your Honor. Ladies and gentlemen of the jury, we have proven our case today that beyond a reasonable doubt, that Mr. Carnley was driving under the influence of alcohol. You heard the testimony, you've seen the video, you've seen the results from the Draeger machine. Mr. Carnley pulled up to the checkpoint on Wayside Road in Butler Street. He had a smell of marijuana, smell of alcohol coming from his vehicle and from himself, and he had an open container of beer in the car. They asked him to step out of the vehicle. We didn't get to see it on the video, but the officer's testimony is that he was stumbling. We did see on the video the slurred speech. He couldn't keep his balance when asked to put his hands on the car. He arrested him for DUI, took him to the sheriff's office. He read him the implied consent, which is required by law. That Mr. Carnley blew into the Draeger, and before he even blew into the Draeger, the machine was tested. It tested itself before and after each blow, and it determined that he had a blood alcohol content of .09. The legal limit in the state of Alabama is .08. We ask that you find him guilty of driving under the influence.
Mr. White?
Ladies and court, ladies and gentlemen, thank you. This is the last time I get to talk directly to you, so thank you again for serving on our jury, and thank all of you for coming and being a part of our law day today. So, I'm here to argue in favor of my client, of course, and the burden is not on my client to prove his innocence, as we discussed earlier. The burden is on the state of Alabama to prove his guilt beyond a reasonable doubt. Much of the evidence that you heard today is Officer Elam, and much of that evidence that would lead you to believe whether a DUI had been committed is not on that video. The very things that he testified about were not on that video. He talked about the eyes, you couldn't see those. He talked about his speech, other than being at the car. We don't know what happened at the initial meeting where he approached the vehicle. He alleged these bloodshot eyes and this smell of alcohol and smell of marijuana, the slurred speech when he got him out, the unsteady balance, but we don't see any of that. None of that in that first part is on video. Why? That's the purpose for the body cam, is for people like you and me to see exactly what happened out there on the side of the road. If all of that was on video, you would be able to see it and be the judge of that, rather than having to understand this officer's testimony, which may be biased, of course, because he is a state officer. Then we look at the video, and these things that he talked about on the video that he testified were evidence of DUI. I submit to you, it's not there. If you recall, my client walked across the intersection alone. He was not escorted. He had been sent to that vehicle for some reason, but he was not escorted back across that intersection. He walked just fine. He got back over there. Officer Elam testified that he thought he stumbled there right going to the car. I didn't see it, but that's up to you to see that or not see it. So you got to watch that video and make sure that you pick out what you think was evidence. I'll submit to you that that video is the best evidence of an offense, if there wasn't such an offense, or the best evidence that there wasn't a DUI. When he got to the car, the officer's opinion of his actions were that his taking the leg outside the car was evidence of a DUI or of intoxication. That's kind of something you just got to put common sense to. The he's instructed to get things out of his pocket. He's sitting in a squad car. He's got to be able to get in his pockets. He had on jeans. You know how difficult that can be. So he raised up. He put his leg outside. Did he do it more than once? I think he did, but I think that you just have to use your common sense. Was that normal, or was he trying? Did intoxication cause that? He was able to produce the items out of his pocket on demand. He was able to produce his driver's license earlier, the officer testified. He was able to do those things that he was asked. Other than the foot outside the door, he complied with the officer's request. Once he was removed and once he was told he was going to jail, we submit to you that he didn't do anything wrong standing outside the car. He was told to lean against the car, put his hands on the car, spread his legs, but to what extent do you spread your legs? I mean, that's subjective to the officer. That's not necessarily, not following that command is not necessarily evidence of intoxication. The Draeger test is a .09. Officer testified he made a mistake on it. There's clearly a mistake on it by his own testimony. Can you trust it? Do we trust the uniform traffic citation that's under oath? Or do we trust the exhibit number 1, which is the test result? He admitted that one was wrong, so do we believe everything else on it? You've got to raise some kind of question in your mind whether it's proper or whether it's correct. He placed Mr. Conley under arrest. He never read him his Miranda rights. Court may instruct you on that. He never read him his Miranda rights. Should he? We believe he should have read him his Miranda rights because he was placed under arrest. Our concern in this case mainly, or in part, is that the first part of this case was made without video. The middle part of it was made with video, and there's no video of the Draeger exam. There's no video of his demeanor. There's no at the exam site I'm speaking of. There's no video of his demeanor. There's no video of his speech. We have no idea of what he behaved like at the sheriff's department. And so you got to wonder what those videos would have showed if they were made as much as they should have. So we would submit to you that the state has failed to prove this case beyond a reasonable doubt, and that Mr. Conley is not guilty of this offense for which he's charged. We trust that you will find that today in your verdict, and we trust that you would acquit him and let him go free on this charge of driving under the influence. Thank you once again for your service today.
Thank y'all for serving on the jury. Thank y'all for attending Law Day. Thank you for making this program and continuing to make this program the best program in the state for Law Day. You heard what Mr. White just told you. Well, there's not a requirement for a body cam. There's no law that says you have to have a body cam. There's no law that you have to have it on the whole time. There's no law that you only have to have it on part of it. There's no law regarding on whether or not you have to have a body cam. By the defendant's own admission, he had been drinking earlier in the day. He admitted it on the video. Also, there's no requirement that to have to read Miranda rights if you're not interrogating the suspect. There was no interrogation of the suspect, so only if you're going to interrogate the suspect and if you plan on using what you get from that interrogation are you required to read him his Miranda rights. If he interrogated him and didn't read him his Miranda rights, then we couldn't use that in court, and that would have been taken care of probably by a motion by the defense before we even got here today. You heard about the best evidence is the video. Well, in this case, the best evidence is the results from that Draeger. The Draeger was .09. The legal limit in Alabama for driving under the influence is .08. That is .01 higher. It is textbook driving under the influence, and we ask that you find him guilty of driving under the influence. Thank you.
All right, ladies and gentlemen of the jury, you've now heard all of the evidence and you've heard the arguments of the able attorneys. Now my job as judge to tell you what the law is. You are not expected to know the law. It's my job to tell you the law. You should not think from anything that I tell you now or in any way that I have ruled that I'm trying to express an opinion about the facts of this case. I'm not. You are the sole judges of the facts. And you're to take the law as I explain it to you and apply it to the facts as you determine them to be. And by doing that, you will arrive at a verdict in this case. Sympathy or emotion are not elements of evidence and must not be allowed to influence you in your consideration of the evidence. So you cannot let sympathy or emotion influence your verdict. At this time, it is my duty and privilege to instruct you on the law as it applies. Now, Mr. Carnley is charged with the offense of driving under the influence. Now, the charge is brought by way of uniform traffic ticket and complaint. You may hear that referred to as a UTC or a UTTC. This charge, this ticket, is not evidence in this case. It is merely the formal method under our Constitution by which the defendant is accused of a crime and placed on trial. It provides no proof, nor any presumption, nor any inference that Mr. Carnley is guilty of the offense charged therein. As to this charge, Mr. Carnley has entered a plea of not guilty. He says that he is not guilty of any charge contained in this citation. Under our system of justice, a defendant is presumed to be innocent of a crime. That means that a defendant, although accused, begins the trial with a clean slate, with no evidence against him or her. The law permits nothing but legal evidence presented before a jury to be considered in support of any charge against the accused. The presumption of innocence alone is sufficient to acquit a defendant, unless you are satisfied beyond a reasonable doubt of the defendant's guilt from all of the evidence in this case. Now, the state of Alabama has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to prove his innocence. As I've already told you, the burden is upon the state to prove the defendant guilty as charged. Before a conviction can be had in this case, the state must satisfy each and every member of the jury of the defendant's guilt beyond a reasonable doubt. Even if the state demonstrates a probability of guilt, if it does not establish guilt beyond a reasonable doubt, you must acquit the defendant. The phrase reasonable doubt is self-explanatory. It is not a mere possible doubt, because everything relating to human affairs is open to some possible or imaginary doubt. A reasonable doubt is a doubt of a fair-minded juror honestly seeking the truth after careful and impartial consideration of all the evidence in this case. It is a doubt based upon reason and common sense. It does not mean a vague or arbitrary notion. It is actual doubt based upon the evidence, the lack of evidence, a conflict in the evidence, or a combination thereof. It is a doubt that remains after going over in your minds the entire case and giving consideration to all the testimony. It is distinguished from a doubt arising from mere possibility, from bare imagination, or from fanciful conjecture. If, after considering all the evidence, you are convinced of the defendant's guilt beyond a reasonable doubt, then it would be your duty to convict the defendant. However, if after considering all the evidence you still have a reasonable doubt, then the defendant is entitled to the benefit of that doubt, and you should acquit him. It is improper for a jury to be concerned with the penalty to be imposed upon a defendant if convicted. If a verdict of guilty is returned under Alabama law, it's the duty of the judge to set the penalty after due consideration at a sentencing hearing. So you are not to let any possible outcome as to sentencing affect your verdict. You are to apply the facts and evidence as you've heard them to the law of the case. In determining what the true facts are in this case, you are limited to the evidence which has been presented from the witness stand, as opposed to the matters which have been stated to you by the lawyers during the course of the trial. What the lawyers have said, both for the state and for the defense, is not evidence in this case. What they have argued to you at various times in the trial is not evidence. They have a right and they have a duty at the appropriate time to comment on the evidence and to draw reasonable inferences from the evidence as they argue their respective positions to you. But what they say is not evidence, however, and you should put what they say in the proper category of your thinking, and it should not be in the evidence category. Now, as I've stated, Mr. Carnley is charged with the crime of driving under the influence. A person commits the crime of driving under the influence if he drives or is in actual control of any vehicle while there is 0.08% or more by weight of alcohol in his blood. To convict, the state must prove beyond a reasonable doubt each of the following elements of driving under the influence. Number one, that the defendant was driving or in actual physical control of a vehicle at that time. And two, that there was 0.08% or more by weight of alcohol in the defendant's blood at that time. Actual physical control is defined as the exclusive physical power, present ability to operate, move, park, or direct whatever use or non-use is to be made of the motor vehicle at the moment. For this charge, the state need not prove that the defendant's ability to drive was impaired. If you find from the evidence that the state has proved beyond a reasonable doubt each of the above elements of the offense of driving under the influence as charged, then you shall find the defendant guilty of driving under the influence. If you find that the state has failed to prove beyond a reasonable doubt any one or more of the elements of the offense of driving under the influence of alcohol, then you cannot find the defendant guilty of driving under the influence. Now, ladies and gentlemen of the jury, you've heard testimony from a witness who has testified in this case. You should take the testimony of this witness together with all proper and reasonable inferences therefrom. Apply your common sense and in an honest and impartial way determine what you believe to be the truth. You should weigh all of the evidence and reconcile it if possible. But if there be irreconcilable conflict in the evidence, you ought to take that evidence, which you think is worthy of credit, and give it such weight as you think it is entitled to. You may take into consideration any interest that any witness might have in the outcome of this case. You are the sole judges of the evidence, as I've said, and of the credibility of witnesses. You may accept or reject any part of the testimony of any witness, and you should accept only the testimony you consider worthy of belief. In determining the weight to be accorded the testimony of any witness, you may consider the demeanor of the witness while on the witness stand, his or her apparent candor or evasiveness, or the existence or non-existence of any bias or interest. Now, I charge you that if you believe any material part of the testimony of any witness was willfully false, you may disregard all the testimony of that witness. So you can accept part of it, all of it, or if you believe they testified falsely, you can disregard all of it. Now, Mr. Farnley has not testified in this case, and that is his perfect right. The Constitution of the United States and the Constitution of the state of Alabama give everyone the right to remain silent. You are instructed that the defendant's choice of not testifying is a fact from which you can draw no inference. It is not to be considered by you as a fact in the defendant's favor, nor is it to be considered by you as a fact to the defendant's detriment. You may not draw conclusions of any sort from Mr. Carnley's choice not to testify. Now, ladies and gentlemen of the jury, for your convenience, the court has prepared for your use, in this case, verdict forms, which I will explain to you. No inference is to be drawn by you from the fact that the court has supplied you with these forms or from the order in which I'm going to read them to you. When you've reached a verdict, you will select and complete the form which corresponds to your verdict. Now, there's one count, one charge, as we have said. So you must consider the evidence as to this charge, and you must determine whether that Mr. Carnley has been proven guilty of this offense charge beyond a reasonable doubt. If you find from your consideration of all the evidence that the state of Alabama has proven each of the necessary elements of the offense charged beyond a reasonable doubt, then your verdict will be, we the jury find the defendant guilty of driving under the influence. And one of your members that you will choose as foreperson would sign as foreperson of the jury. If, on the other hand, from your consideration of the evidence or lack of evidence, you are not convinced that the state has proven each of the essential elements of the offense of driving under the influence beyond a reasonable doubt, then you must find the defendant not guilty. And the form would be, we, the jury, find the defendant not guilty of driving under the influence. And one of your members, the foreperson, would sign that verdict. Now, ladies and gentlemen of the jury, all 12 of you must agree. You may see that there are 14 of you. We'll get to that in a minute. But 12 of you will go to the back and deliberate. All 12 of you must agree before you can reach a verdict in this case. Your verdict must be the verdict of each and every juror. You are the sole judges as to the weight that should be given to all the testimony in this case. The judge's duty is to decide the law. The jury's duty is to determine the facts. I have no opinion as to the facts of this case. I don't want you to think from anything that I've said in this charge or from any ruling that I've made or by anything I've done in this case that I think one way or another about the facts of this case, because I do not. That's your function. Ladies and gentlemen, when you've reached a verdict, then you will complete one of the verdict forms from the forms that I've provided. And as I've explained, the foreperson will sign only one verdict. When the verdict has been completed, it will be necessary for you to return to court and give your verdict. In the meantime, until you reach your verdict, and until the verdict has been received and you have been discharged, it is absolutely necessary that you all stay together and that you not separate even for a moment. Ladies and gentlemen, during your deliberations, you will have with you the verdict forms that I've just reviewed, along with any exhibits or documents that were introduced. I would suggest to you that the first thing that you do upon getting to the jury room is to select a foreperson to help govern your deliberations and help ensure that things will run in an orderly fashion. This is only a suggestion. You're certainly free to conduct your deliberations how you see fit. Once you've reached a verdict, knock on the door, let the bailiff know that you've reached a verdict. You will be called back into court. Now, when you get to the jury room to start your deliberations, you will be in charge of what takes place after that. If you have a question, you should have your foreperson write the question out. Write it out on a piece of paper and give it to the bailiff, and the bailiff will bring it to me. And at that time, I will decide whether or not we need to bring you back into the courtroom to discuss the question or give you any other information. It might be a question I can answer. It may be a question I cannot answer. So you just need to write it out and provide it to the bailiff, and then I and the attorneys will consult. Okay. What says the state to the court's oral charge?
We're good, Your Honor.
Vince?
Defense is satisfied, Your Honor.
Now, at this time, I need to dismiss our alternate jurors. Now, I want to thank you for your time and your willingness to serve, and I've seen you've all been attentive this morning, and we appreciate what you've done, but we can only send 12 of you back to deliberate. So what we're going to do, when I announce who the alternates are, I'm going to ask you to stay where you are and send the 12 jurors back to the jury room. And when you get back there, do not begin to deliberate until you have received the exhibits. Ms. Carly will send those back by the bailiff. Once you have received the exhibits and all 12 of you are present, you can begin your deliberations. The alternates are Lauren Thompson and John Paul. Okay, so Ms. Thompson, Mr. Paul, if you will remain in the jury box, and bailiff, you may take the remaining 12, all right, back to the jury room.
Your Honor, the counsel, I will need to take the video.
They want us. They want to watch
It is an evidence.
the video. Okay, you may be seated. Judge Cole, do you want the alternates to stay in the jury box while you talk, or you want to let them go back
I'm gonna let
in?
them do what they feel comfortable doing. I'll leave that up to y'all. Y'all wanna go back with your
We won't
friend?
have to come back up here, will we?
No.
No.
Okay, at this time, Judge Cole is going to speak to you about the law, some of the law about the case we've had, and try to answer any questions.
All right, thank you, Judge Stern. All right, good morning, everybody. I'm gonna come out here with y'all if that's okay. I want y'all to be comfortable this morning, okay? Everybody in here friends. Anything you say in this courtroom, anything you say is not gonna be embarrassing, okay? Every question's a good question. I want this to be a fun experience for you, but I need y'all to interact with me a little bit, okay? I've done this for several years now. We have more fun when everybody participates instead of me sitting up here talking about things that you don't care about. So, I am Judge Cole. I am the district and juvenile judge. As Judge Stern said this morning, he's the circuit judge, and Judge White over here is our other circuit judge, and they're the court of record. I handle mainly the traffic cases, which normally I would have handled this case from the onset, but this was a special case that we used to present to y'all for Law Day. A couple things I want you to remember. Just because you graduate today doesn't mean you need to stop learning, okay? Continue to learn whether you go to college, you're on a new job, learning a skill. Keep learning, okay? I learn something every day. Usually it's the hard way, but continue to learn, okay? Make life a little easier on yourself. Education is power, okay? The more you know, the better off you can make good decisions. Good decisions. Make good decisions, okay? Y'all about to be adults if you're not already 18 years of age. I, myself, Judge Stearns, Judge White, we don't want to see y'all up here in orange or what we call the candy cane jumpsuits, okay? We don't get paid by the person we see. So, make good decisions. It don't take one bad decision to change your whole life. We've seen it. We've seen good people who've made one bad decision, they've ruined their whole life. So make good decisions, okay? I want to thank the lawyers. I think they've all left the courtroom at this point. And Mr. Carney, these lawyers volunteered their time this morning. They didn't have to do this. They chose to do this. And we enjoy doing this for y'all's benefit. And we appreciate y'all being here. Appreciate the schools allowing y'all to be here and do this. Appreciate, I believe Ms. McClung's back here. Board of Education Superintendent, we appreciate you allowing your schools to come here. Tech guys, Mr. Burkett and I think Travis, Jamie and Travis back there, we appreciate y'all providing the technology today. We do have some teachers, I believe principals here. I think we have Mr. Williamson here. Appreciate y'all being here. All our teachers do a fine job. We thank y'all. Let's talk about the case a little bit. Where's my alternates at? Raise your hand, alternates. All right. Does anybody want to volunteer how they would have voted today? Guilty or not guilty?
Not guilty.
Not guilty. What about you, Ms. Thompson?
I would say guilty.
Guilty or not guilty? All right. Whoever feels that he was guilty, raise your hand. Guilty now. If he was guilty, raise your hand. Okay. Not guilty, raise your hand. Okay. Okay. Anybody want to, from the guilty side, what you basing your decision on, Ms. Thompson? You feel he's guilty based on the Drager or something else?
Well, I think the test is the main part. I do think that the officer was a bit of an unreliable witness, but I mean, I think he seemed drunk on the video, and I think the test says a lot. So.
All right. Thank you, Mr. Thompson. Sir, Mud, you want to volunteer, Wayne? That's okay, you don't have to. I'm not here to embarrass anybody, okay? From a not guilty standpoint, who wants to volunteer why they would think he's not guilty? Raise your hand and I need one at a time. Anybody want to do it? You want to do it? Stand up. All right, order now, order.
The amount of evidence that has been presented, as seen from the venue and as he's spoken, some stuff did not match as what the video has been shown. But I can say the main reason he's not guilty is just they didn't seem right. What's seen there and what has been spoken, and what's shown as the two files doesn't seem correct.
Okay, so you feel the video was the best evidence, I guess?
He gave enough evidence, but some of the other stuff he said was not there as seen.
Okay.
Some stuff was not specifically said from the man to do everything. So if the man was being more specific, the officer was more specific, told the man what to do, it would have been made more sense.
Okay, I appreciate that. Thank you for, anybody else? Anybody else want to have an opinion of why they would have found him guilty or why not? We got one hand back here in the back. Either, you argue whichever side you feel. You tell me which one.
He had admitted that he had been drinking before this incident.
So would you found him guilty?
I would have found him guilty.
Okay, tell me why. Go ahead, you can tell me why again.
How long before he had been drinking, but he had been drinking that day.
Okay, all right.
And then along with the tests that had shown up that he had been drinking. I mean, driving under the influence.
Okay, thank you. Ms. Thompson, you want to elaborate some more?
Okay, I just have like kind of a question.
Okay, go ahead and ask your question.
It was a 30-minute drive from the scene to the station where he got the test.
Correct.
Would his alcohol level not have been higher had he been tested on the scene? Because there was like a long period of time.
That's a good question. Sheriff, you want to weigh in on the Drager example? I'm gonna let Sheriff answer some of these questions.
So a lot of times, it depends on when you consume like a beer. Just say we're gonna go with beer. If you drink a beer and he just got pulled over and he just drank it, his alcohol level is actually going to be climbing during that time because his body is absorbing all of it. If it was later on, he had the beer an hour late or prior, it would start to drop on the way. But most of the time they require a 20-minute period to make sure nothing's consumed. So a lot of times the drive, they use that as a 20-minute period before they would test them anyway to get a good reading.
All right. That answer your question, Ms. Thompson?
Yes.
Thank you. Thank you, Sheriff.
Yes, sir. Thank you.
All right, let's do this. Jury summons. This was a little bit different because we picked the jury because of time constraints. Normally, the attorneys would have an opportunity to ask everybody questions about who you are, where you work, kind of some background information where they could have made a better decision on picking a jury. One thing I do implore you, at some point in your life, you will get a jury summons. I ask you to serve. Now, I didn't say this yesterday, but I should have said this yesterday. When you get a jury summons, you're supposed to be in this courtroom. If you disregard a jury summons, then we can ask the sheriff to come pick you up or put you in jail. We don't want to have to do that, okay? So if you get a summons, now we understand there may be some reasons that you may have moved and things like that, but we can deal with that. If you get a summons, make sure you show up, unless you're excused beforehand. So it is required. Now, unless you run for office, most likely this is the only time you're going to be able to participate in our government, okay? It's important. We do have a constitution for a reason. And as we heard today, this defendant, Mr. Connolly, which thank you, Mr. Connolly, for doing this for the students. He didn't have to do this. This is part of his life that's on trial here today. We appreciate him allowing us to present this. This is a real trial, y'all. This is not play. So it's important that we participate in our system. What rights? Anybody know what the Bill of Rights are? Very important. I would ask you, if you don't know what the Bill of Rights are, you go home and read and find out what they are. Because that's what our government and our country is founded on, the Bill of Rights. And that's the only reason we have the Constitution we have, because the Bill of Rights wasn't added, we wouldn't have the Constitution as we see it today. That was added because they needed these to protect our rights as citizens of the United States. So that's an important concept. So go back and read that, and you'll learn about some things that's important to us as in our government, okay? A little bit about the trial. Defendant, a couple things. He had due process today. He had an opportunity to have a trial in front of a jury here, a jury of his peers. And that's another thing about jury service. It's important for everybody to participate because you don't want a jury box over here full of old white people or old black people. You want and you're a black defendant have a white jury. You don't want that. You want a cross section. You want a jury of your peers. And I hear this all the time. That's not a jury of my peers. Well, you got to participate. Everybody needs to participate to make this system work. Okay? So he had due process. He had a right to a trial, public trial. Had y'all here to watch him on trial today. What y'all notice about Mr. Conley today? He chose not to testify today, which he had every right to. You have a right of non-self-incrimination. You don't have to get up here on the stand and incriminate yourself. So he chose not to testify, and he has every right to do that. So he chose that. You heard Mr. White have an opportunity to cross-examine Trooper Elam. Confront witnesses. You have a right to confront your witnesses. There's a reason we have these concepts because, in certain countries, you don't have this right. They just go pick you out of bed one night and they throw you in jail and may keep you there for years. Our system is not perfect by no means, but it's better in a lot of countries. You do have rights as individuals in this country. Who wants to be a lawyer in here? Got one over here. About what we had yesterday. It's getting kind of few and far between. We encourage you to consider the law, okay? Our county, we do have an aging bar, so it's hard work sometimes, especially in a small rural county, but it's rewarding. I was a lawyer for 20 years before I became a judge. It's grueling work sometimes, and it's not romantic like some of these legal shows portray them to be. But it's a good job, okay? All right, what I'm going to do at this point, has anybody got any questions for me or Mr. White and Ms. Grosso are here as far as the prosecution or defense? Anybody got any questions that you want to know about? Mr. Witt, excuse me. Y'all don't be bashful. If y'all got questions, let's hear them. I had the sheriff, he left, didn't he? Yeah, go ahead. Do I regret decisions I've made? I don't regret any decisions I've made. There's been a lot of decisions I've made that have really taxed my Constitution, I guess, for lack of a better. Usually the most cases I have the worst headache or most problems are, I do a lot of juvenile dependency cases, and I have to decide where custody of a child may or may be. And that's very, it's grueling to make the decision because I'm messing with somebody's life there. I'm trying to make the best decision for that child at the time. I use all the evidence I get, my knowledge, and use a little common sense, so I usually don't regret one when I make it. Now, do I question myself sometimes? Yes. Any other questions?
Judge Cole?
Yes.
You have a verdict?
All right. Thank y'all. We got a verdict. Good luck in everything you do. This is your courthouse, so you have a right to be here. So if you want to come back and visit, please do so. Don't come see us in Orange, okay? All right. Thank y'all. Good luck.
Okay, ladies and gentlemen, don't know what the verdict's gonna be, but regardless, whether it's not guilty or guilty, we don't want any outbursts. And these 12 people that have had to make this decision, that's not an easy decision for them to make. So I'm gonna ask each of you not to belittle them for their decision that they made. They're exercising their responsibility and duty under the law. And as Judge Cole said, you may one day be up here, and until you're in that jury box and having to decide somebody's fate, you don't understand what a significant weight and burden that is. So as the theme today is be civil to each other, please exercise civility when this verdict comes in. Okay, if you'll bring me 14 jurors, please. Everybody stand. 12 jurors, excuse me. We got two out. Okay, you may be seated. Okay, ladies and gentlemen of the jury, have you reached a verdict? Who's our foreperson? Okay, Bracken, if you'll hand your verdict to the bailiff. Thank you, sir. Okay. Defense will please rise. We, the jury, find the defendant guilty of driving under the influence. Is your verdict unanimous? Okay.
Judge, we would like to poll the jury.
Okay. All right, let's see if I got the list of. Now, there's been a request to poll the jury. So when I call your name, if you will say if this is your verdict. Graydon Cole? Okay. Claire Hart?
Yes.
Mr. Pettis?
Yes, sir.
Jonathan Carter? Wendy Aguirre? Yes? Okay. Christian Smith?
Yes, sir.
Lakin Stone?
Yes, sir.
Destiny Hanks?
Yes.
Anaya Kyles?
Yes, sir.
Bryson Patterson?
Yes, sir.
Savian Odom?
Yes, sir.
And Levi Preston.
Yes, sir.
All right?
Satisfied.
Thank you. Satisfied?
Yes, sir.
Okay. Thank you, ladies and gentlemen of the jury. We appreciate you being attentive this morning and doing your civic duty. Now, we are on schedule, believe it or not. So, at this time, we appreciate everybody being here. We appreciate, as I've said earlier, everybody's cooperation. This is a unique program. We appreciate everybody being here and participating. And best of luck to you. This is an exciting time in your lives. In a couple of weeks, you'll be graduating. And best of luck to you in your future. At this time, the Law Day program here in Escambia County is concluded. Thank you.